Hello and welcome to Module 29. I am Professor Rashmi Raman and this module is titled National Responses to International Crimes. As we do with all other modules, we will start by understanding why we are studying this. We are studying this in order to understand domestic prosecutions and hybrid mechanisms and other local responses. This module aims to familiarize you with the national responses that are traditionally taken and are inventively taken to international crimes in Sierra Leone and Rwanda. This will also help you understand why national responses to international crimes are so rigid and why there is a need for international intervention for these crimes. If, as you will see in the modules, there has already been a national version of this. Let us begin with understanding the various heads that will be discussed under this module. Firstly, we will understand national responses as resistive alternatives to the international legal mechanisms. Secondly, I will spend some time telling you about Rwanda and the Gacaca courts in Rwanda. Now, Gacaca courts traditionally, in the aftermath of the genocide, as well as the major objectives of the Gacaca courts, these will be the subjects under our consideration as far as Rwanda is concerned. We will then move on to speaking about Bangladesh, the International Crimes Tribunal for Bangladesh. Thirdly, in this module, we will speak about the hybrid tribunal in Sierra Leone, and we will conclude with underlining the criticisms and responses to national responses to international crimes. Let us begin with a broad introductory note. It is an idea that has been prevalent that international criminal justice must be delivered by international courts or other international mechanisms. What are the main arguments to support this? Firstly, the joy and the optimism around the creation of the ICC, for example. On the other hand, the ad hoc tribunals such as the International Criminal Court, courts for Rwanda and Yugoslavia, and other United Nations led interventions in addressing international crimes have contributed to the notion that an international is inherently better or more valuable than national. This notion is misleading on at least two grounds. Firstly, even when the primary modus operandi is international, that is an ad hoc tribunal or even the ICC, domestic support is crucial, absolutely crucial for the effective administration of justice. Secondly, although international responses may be popular way to advertise or publicize the end of impunity for a crime, domestic and state-led efforts at addressing the international crimes are not in fact infrequent. In reality, there are more domestic mechanisms than there are international, despite what we have studied in this entire paper. This module's object is to seek to familiarize you, the student, with some such national responses, including the tribunals in Bangladesh, the so-called ICT, and the Gacaca courts in Rwanda. National responses as resistive alternatives to international legal mechanisms. Now, you know that in the past, in other modules, we have argued that international legal mechanisms, including such mechanisms useful for the dispensation of international criminal justice, that is ad hoc tribunals and even the permanent court, have the potential to function as a new tool of civilization. These arguments are motivated by international political and economic aims to consolidate and bring together a comity of nations united in their fight against a crime. Far from being a defense of the individual against the state, international legal tools have become part of the standard protocol for dispensation of justice as a justification for the use of external force by the state against other states and the individuals that it sheds responsibility for its unfavorable outcomes. Standard part of the justification for the external use of force by the state against other states and individuals that it sheds responsibility for its unfavorable outcomes. It hinders and is often dismissive of resistive or alternate models. Against this political backdrop, a national response to international crimes offers an attractive and far more politically uncomplicated alternative to international mechanisms. They can be appropriated and tailored to address context-specific issues, in that an international mechanism is usually devoid of any external involvement and may therefore arguably enjoy a greater sense of legitimacy, even if not locally, at least among the assembly of states or the collective consciousness of all states. I would now like to talk to you about the Gacaca court system in Rwanda. Transitional justice in Rwanda. In the aftermath of the tragic Rwandan genocide of 1994, occurs broadly in three different ways. One, and the one that you know until now, is the International Criminal Tribunal for Rwanda, set up by the United Nations, operational since 1994, dissolved in December 2013, and succeeded by the MICT. Secondly, formal criminal trials at the national courts of Rwanda, and finally, locally based Gacaca trials. What are Gacaca? The word Gacaca literally means under a tree in Kenya, Rwanda. Gacaca courts were instituted by the Rwandan government in the year 2001, and these are traditional community-based informal courts, each overseen by locally elected representatives functioning as judges. Gacaca courts traditionally, in the pre-genocide period in Rwanda, Gacaca system, to compare it with the Indian system, was basically a system like our Panchayati Raj that we have under our country today, constitutionally protected. These Gacaca courts offered alternate conflict resolution solutions in which the aggravated party and the party who had done the wrong were brought before each other and came together before a council comprised of village elders and the most respected local council people to discuss and sort out their problems. Any punishment deemed just was given by the elders, always had a restorative element to it, and in fact it never included the strict imprisonment of the perpetrator. It was more creative, locally tenable ideas such as working in the fields, helping each other out, performing community service, digging common roads, etc. But in the aftermath of the Rwandan genocide, the Gacaca idea also quickly evolved. And Gacaca courts in post-genocidal Rwanda turned into a place where the fates of people who were suspected to be actually involved in the genocide were decided. These courts by now had started accepting women as participants among witnesses and judges. They also appointed judges based on election now and were open to the idea of sentencing convicted genocide criminals to a regular state prison, although with a slightly modified or mitigated sentence. Both these were new steps for Gacaca courts, which shows us that they quickly evolved to fit the need of the hour. They not only focused on the ways of war through tribunals, but also as truth commissions, which they did by punishing criminals after encouraging the community at large to participate in a public discussion about each experience of conflict and to provide a platform for the victim and the perpetrator and the witness to come together in an effort to reconcile them and reconstitute society. The major objective of the Gacaca courts functionally is to reduce the burden on the ICTR. The ICTR, as you know, was facing a large number of prosecutions. However, these prosecutions were of those most responsible. The Gacaca courts honor no such hierarchy. Everyone accused of genocide is welcome before them. The second objective behind their establishment is to establish the truth about what happened. Thirdly, to accelerate the legal proceedings for those accused of genocide and war crimes in Rwanda. Fourthly, to eradicate the culture of impunity among Rwandans and also to reconcile Rwandans and reinforce their national identity and create a sense of unity. They wanted to use the capacity of the Rwandan society to deal with its own problems through a justice system based on time-honored Rwandan traditional custom, that is Gacaca. I would now like to spend some time discussing with you the International Crimes Tribunals of Bangladesh, ICT-1 and ICT-2. In 1971, Bangladesh faced a war for liberation. Many atrocities took place during this war and resulted in the creation of the International Criminal Tribunal. Now, this tribunal did not come into being for a long time. It was only in 2010 that Bangladesh formed a separate tribunal for the purpose of delivering justice for the grave war crimes and crimes against humanity committed during the Bangladesh Liberation War that led to the creation of the state that we know today as Bangladesh, following its separation from the state of Pakistan and its metamorphosis from East Pakistan to independent Bangladesh. During the war, a large number of civilians were injured, killed, sexually assaulted, and internally as well as externally displaced from their homes. The main culprits of these heinous acts were the armed forces of the Pakistani army as well as their paramilitary allies and some suspected allies and troops of non-state parties within Bangladesh. The Bangladesh legislature, after independence, created the International Criminal Tribunals Act in the year 1973. However, this did not result in the creation of a post-war agreement and result in the birth of the tribunal itself. It was only in 2008 when the Awami League, which was the party in force at the time of the 1971 War of Independence, when the Awami League won the elections again in 2008, they brought back to life the long forgotten ICT Act and created a tribunal in the year 2010 for ICT-1 and a subsequent chamber complementary to ICT-1 in 2012 known as ICT-2. These tribunals have given themselves under the ICT Act of 1973 jurisdiction in the matter of war crimes, crimes against humanity and genocide, including disruption of peace. However, unlike other tribunals that we have discussed so far, the Bangladesh tribunal has the option of awarding the death penalty during its sentencing. This has led to much criticism from all around the world, including calling the system in Bangladesh backward or unevolved. We will of course leave these for you to discuss and debate and draw your own conclusions on. We now want to talk about the hybrid tribunal in Sierra Leone. What are hybrid courts? Hybrid courts are a new type of court. They do not focus on any one single aspect of the crime, unlike international criminal courts or like specific criminal tribunals. They utilize laws from a national context and transpose them with a little bit of borrowing from international law. The resulting code is an interesting mix of municipal and international. Parallel to this, the judges and the staff are also a mix of national and international. These hybrid courts are seldom subjected to political pressure or coerced into using old and redundant laws that have limited applicability, unlike domestic courts, which run a big risk of using outdated laws. Since hybrid courts are created through special agreements between the national and the international, they also have an ease of access to the national, which means that they have the unique position to collect information and witnesses and also to inform and educate the masses, because the courts are usually not removed spatially from the circumstances where the crime took place. Let's now spend a few minutes talking about a brief background to the conflict in Sierra Leone. You have already studied the Sierra Leone Tribunal in a different module. But in 1991, the Revolutionary United Front, the so-called RUF, along with Charles Taylor's National Patriotic Front of Liberia, the NPFL, came to Sierra Leone and tried to intervene and overthrow the existing Joseph Momo government. This intervention led to a security situation which escalated quickly into a conflict and resulted in a civil war that spanned almost 11 years. In 1985, Siaka Stevens stepped down from the dominant position that she was occupying in Sierra Leone, and the reins of the country were handed over to Major General Joseph Momo. In the 7 years that Momo held office, after the resignation of Siaka Stevens, he engaged in several acts of corruption which have been proved by municipal courts, and these led in collaboration with other factors to the economic downfall of the country. The Sierra Leonean state was soon unable to pay its workers, and civilians had to take resort to looting and ransacking public property, government offices, and government property. At the time that Charles Taylor and his forces entered Sierra Leone, there was nobody to hold them back. Particularly, the energy of the youth who had taken to the streets and in fact joined Taylor and the forces of intervention specifically led to a concatenation of unrest which resulted in the civil war. Soon after the conflict ended, the hybrid tribunal was created. Since the civil war and the internal conflict in Sierra Leone lasted almost 11 years, and during this time, not just people but an entire generation were terrorized with gruesome crimes such as mass amputation, mass rape, and a whole lot of undocumented atrocities. When this finally ended in January 2002, the United Nations had to accept the request of the newly created democratic and peaceful government of Sierra Leone to set up a special court to address the issues that were brought up in the 11-year civil war and to provide justice to the victims of serious crime during the civil war that lasted over a decade. The negotiations between the United Nations and the new government of Sierra Leone led to the creation of the world's first ever hybrid international criminal tribunal. This court would go on to try the perpetrators who had committed crimes after the 30th of November 1996, that is, from the time of the dismantlement of the Momo government up until 2002. It was the first ever modern day tribunal to sit in the same country where the crimes had actually taken place. This is a very important point because no other tribunal had been able to sit politically in the same place where the crime took place. The tribunal for Sierra Leone was also the first of its kind to be voluntarily funded by contributions from states parties. The statute of this court, the hybrid statute, gave powers to the prosecutor to bring charges for war crimes, crimes against humanity, and other serious violations of international criminal law, as well as international humanitarian law. Sierra Leonean law was also an important factor in figuring out what were the crimes that could be penalized by the court. In the final part of this module, having discussed with you the individual examples of tribunals which have responded nationally, let us talk about criticisms for these responses. Just over 12 months after gacaca courts were instituted, when it was evidently premature to make any meaningful assessment of its impact, human rights advocates such as Amnesty International and Human Rights Watch voiced serious concerns that gacaca courts fell far below international standards of due process and that in their procedure they failed to sufficiently protect victims, which has been an important part of international criminal law in modern times. Academic literature, particularly from authors with a background in international human rights, have largely mirrored these arguments. Some claiming further that the draconian or so-called draconian gacaca courts must be abandoned if Rwanda ever truly wishes to pursue reconciliation. The counter to these has been that the gacaca successfully ran for 21 years. But these pieces argue that the most important outcome of the gacaca process, comparable to that of the national court's prosecutions in Rwanda and in fact the ICTR itself, should be the punishment of the perpetrators of genocide, which is the only thing in future that would help to deter other criminals and to eradicate the idea that impunity could exist for any crimes. If one takes this broad view, justice will be achieved and the gacacas will only be deemed successful when perpetrators of the genocide have been found guilty and sentenced according to the severity of their crimes. Any failure to mete out that kind of serious punishment to those found guilty of genocide and to do so without a respect for commonly accepted principles of due process would, one might argue, create a certain kind of democratic deficit in the gacaca. But this is a kind of fairly rigid liberalist human rights critique, and it assumes that gacaca is aimed at deterrent formal justice, because the argument is based that it operates in contravention of universally recognized fair trial principles. That because gacaca courts deviate from what we understand or what the globalized understanding of due process and criminal justice and so on and so forth is understood, and how such justice must be achieved, through what kind of procedures and through what kind of punishment, the argument concludes, this liberal human rights view concludes that it is illegitimate. But the counter is that while the gacaca courts may indeed pose some legitimacy concerns, this absolute tone of the human rights critique is worrying in and of itself, because it seeks to create a hegemony of the global over the local and seeks to presume that local solutions, which still enjoy the support of the nationals and have traditionally served the purpose of the society in which they were conceived and in which they operate, They seek to undermine the legitimacy and the traditional knowledge of these societies. Like the ICTR, Gacaca courts are not concerned with the prosecution of RPF soldiers and top-ranking militia and top-ranking politicians. They are not interested in a form of victor's justice. In fact, the search for truth under Gacaca courts also is largely predetermined, where local administrators assist the Gacaca elders or the Gacaca judges in the collection of information. This information is just validated by large gatherings at Gacaca assemblies. What this creates is a passionate defense of the truth. And in fact, Gacacas are some of the most emotional forums at which human rights activists have found that the overtly simplified understanding of justice gets seriously challenged by this traditional mode of dealing with the complexity of a crime as horrendous and as deeply woven into the fabric of Rwandan society as the Rwandan genocide. It isn't really a traditional indigenous justice versus modern Western justice conundrum here. It is the idea that both can coexist and that working together, the Western model of international supplements and in fact complements the national models. Thank you.